I'm Dan Nelson of Nelson & McCullough LLP. I'm talking today about the Google Books case and Judge Chin's refusal to accept the proposed settlement agreement that would allow Google to go forward with its plans to digitize most of the books in the world and make them available for sale on the internet. Judge Chin ruled that this would essentially give Google a monopoly. And more importantly, Judge Chin ruled that the proposed settlement ran afoul of copyright owners' rights and wasn't fair or equitable to the owners of copyrighted material. The major sticking point was whether the proposed class action would be a class of individuals allowed to opt in and have their books distributed through Google Books, or whether it would cover everyone with an opportunity to opt out. The difference between the two proposed classes would be the opportunity for Google to exploit millions of so-called orphaned works where the copyright owner didn't come forward or couldn't be identified. Orphaned works is a bit of a misnomer, since it implies, in fact, that the work has been orphaned, rather than the fact that it may just be logistically difficult to ascertain who owns the copyright or where they are. My view is that Judge Chin got it right in trying to strike a balance between the public's right to have information and the rights of the copyright owner to control the exploitation of their copyrighted work. While this settlement agreement would have cleared the way for the sharing of substantial information, it also would have tread on the rights of copyright owners. Judge Chin did expressly leave open the possibility of a revised settlement agreement that might be narrower and address the issue of individuals being allowed to opt in as opposed to being required to opt out. This is largely viewed as not much different than traditional licensing agreements, which of course frustrates Google's potential rights grab over these so-called orphaned works. But I think it's necessary and appropriate that Judge Chin was restrained in not taking the opportunity to preempt Congress on the issue of orphaned works and not to create policy in this respect. While the case has been ongoing since 2005, it's unclear what the next step will be. It's our hope that some balance will be struck in the future between the rights of the copyright owner to control the use of their copyrighted material and the access that the public wants to this information, particularly if it can be done in a way that compensates fairly the owner of the copyright and allows for them to decide whether their copyrighted works are incorporated.